Hearing in the appeal, Commissioners for Her Majesty's Revenue and Customs against Taylor Clark Leisure.
My Lords.
Yes, good morning.
Good morning, my Lords. My Lords, the appellants in this case agree with much of the extra division's analysis of Section 80 claims in the context of VAT groups. Where the appellants take issue with the extra division's decision is in its conclusion that Carlton clubs were acting as an agent for Taylor Clark and the reasoning by which it came to that conclusion. And there are three key points which we take issue with the extra division's reasoning. The first point is where the extra division state that when one is looking at a claim submitted by a group or a former group member, it must normally be construed as a claim on behalf of the representative member. It's that word normally which appears at paragraph 27 of the decision, and that's at MS 131. And in short, we say there is no basis for any presumption. The second key issue is...
Sorry, which paragraph was that?
It's paragraph 27.
Yes.
It should be at MS
Yep, got it.
131, I think, my Lord.
131. Yes, okay. Yes. Yes, I mean you criticise the reasoning as starting from the end. Really,
Indeed.
It must be made valid, and therefore it must be construed as an agency claim.
Indeed, my Lords. And if by using the word normally there, one is importing some sort of presumption in this situation, we say that's illegitimate. There's no presumption one way or the other when one is construing a document to see whether there's been a purported agency. The second key issue which I propose to develop is we say that these letters, the claims letters submitted by Carlton, properly construed, do not fall to be construed as being by Carlton as purported agents for Taylor Clark. And we say that the extra division paid insufficient attention to the text of the letters. Rather, they relied upon the headings of the letters rather than looking at what the text actually says. And the third key issue in relation to this agency point links in with the findings in fact. The findings in fact included a finding that Taylor Clark did not know that there was any right to claim until after the expiry of the time limit. So they did not know that there was any right to claim when Carlton submitted these claims. And in our submission, that absolutely precludes a finding of agency based on the normal way of a principle authorising an agent and the agent accepting to act as agent for the principal. It doesn't exclude, as I accept, agency arising in the slightly different situation of an individual purporting to act as an agent followed by ratification. But what the extra division didn't do is that next step, having construed the letters on the basis that Carlton were purporting to act as an agent, they didn't take the next step of looking to see whether there was any ratification on the part of Taylor Clark.
So what do we do on if we?
Well,
get
that
to that
does
point? Do we have to make up our minds about the law of ratification without it having been argued at all below?
I think it does create a number of problems. Factually, it creates a problem because I think there are no findings in fact relevant to ratification. So this was ultimately determined on two preliminary issues before the first-tier tribunal. So I suppose in practice it could go all the way back to the first-tier tribunal to make findings in fact based on ratification.
Well, the ratification would presumably be reliance, whenever that took place for the first time, on those letters as giving Taylor Clark a claim. That would, if they were written on behalf of Taylor Clark, then that would surely be a ratification.
I would put it slightly different, my Lord. I would say it would be reliance on the letters on the basis that Taylor Clark are accepting Carlton, are acting as their agents. So one is actually ratifying the fact that someone is your agent.
Yes.
Now, the oddity here is that in the main, Taylor Clark have not, until very recently, suggested that Carlton were acting as agents. The arguments before the first tier tribunal...
I saw that. It was the opposite. It was, yes.
The arguments, as I understood them, the arguments before the first tier tribunal, and certainly the upper tribunal, were to the effect that if someone made a claim, as long as someone made a claim in time, anyone else could come in and assert the right to that claim. But it wasn't done on the basis of agency. So that does create a...
There's a claim floating around in the air, and anyone can take advantage of it.
Anyone can grab it.
That was Miss Whipple's argument.
Indeed.
Yes.
Indeed.
We
Now,
have to bear in mind, presumably, that what we're dealing with here is a statutory appeal on a point of law
indeed.
against the decision of the upper tribunal.
And if there are no findings of fact relating to ratification, that is that.
Indeed. Well, ultimately, it should have been for the taxpayers here, if they were relying upon agency, to make sure that they secured the relevant findings in fact at first instance.
We can't be sending it back now.
Well, this case has certainly been going on for a very long time.
No, but in matters of principle, we wouldn't send it back to find facts which no one attempted to advance at the first tier.
Well, I'm obviously happy to accept that as
that was how I understood it.
Indeed.
I think you missed a step in the other side's argument, which is, and it seems to be in, well, there's certainly a step in their argument, whether it was accepted by the extra division you can help us on, but it seems to be that where you have a VAT group, even though in domestic statutory terms, the representative company is the company which faces the revenue and deals with the revenue. Nonetheless, every single member of the group can come in and make a claim on behalf of the group to the revenue, which the revenue is then obliged to deal with face-to-face with the representative company. That seems to me the core argument.
Well, the 3 points I've dealt with have all been in the context of perhaps classic agency, which is, as I read the extra division, their case is based on agency.
Yes.
What I was going to go on to say is there is a fourth point, which is really the point my Lord has just made, which is certainly set out in the written case for the respondents. And I think, as I read their written case, it's really perhaps their principal argument, but it wasn't the argument which was relied upon or accepted by the extra division. And it is this point where they say, really out with the scope of normal agency, in a VAT group, a member or indeed a former member of a VAT group, where they make a claim, that is deemed to be a claim on behalf of a single taxable person because in some way they are infused with part of the single taxable person, or they're embedded in the single taxable person. So therefore it's automatically a claim. So I was going to come on to that point perhaps after I've dealt with what I see as the reasoning of the extra division, and then I'll deal with what seems to me to be a point put forward by the respondents, but is not what the extra division relied upon. So turning to the question of agency, in my submission it's clear from the judgment that the extra division decided that Carlton was in fact an agent here for the representative member. Obviously, HMRC, as we set out in our written case, quite accept that a representative member could appoint an agent to act on their behalf for a Section 80 claim. So the question is whether, in fact, Carlton were acting as agent here. The findings, in fact, are perhaps a starting point here, and perhaps I could take my lordships to the relevant findings, in fact, in the decision of the first tier tribunal, starting at paragraph 54, which is at MS 329. MS 329, my lords. So the relevant findings of fact are, first of all, paragraph 54 says, throughout 2006 to 2009, Carlton and its advisors submitted a number of claims to HMRC for repayment overpaid output tax. These claims concern various aspects of the bingo business, which Carlton had operated as part of Taylor's VAT group from 1990 to March 1998, and thereafter under its own VAT registration number. During these periods, Taylor made no approaches to HMRC seeking to reclaim overpaid VAT in respect to the bingo businesses formerly operated as part of its VAT group. 55. Taylor neither instructed nor authorised any of the voluntary disclosure letters, that's the 16th of November 2007 and the 8th of January 2009 referred to above, sent by Carlton seeking repayment under Section 80. These claims were made by Carlton and were not claims made by or on behalf of Taylor or on behalf of both of them. Whether Carlton were entitled to make these claims is a different issue. Taylor has not submitted any Section 80 claim in its own name in relation to any of the appeals referred to above. And then can I just also pick up the last sentence in paragraph 57. This is dealing after HMRC had actually made a payment initially to Taylor and then initially to Taylor under the automatic bank transfer system. The last paragraph is, these payments came out of the blue so far as Taylor were concerned, as they were not aware until then that they had any potential claim under Section 80.
Biblical. Yes.
So,
Manna from heaven, right?
yes, I think it was. Now, those findings in my submission prevent a conclusion that there is agency based on authorisation by the principal to do an act and acceptance by Carlton as agent, because it's quite clear Taylor did not know about the claims, therefore they can't have authorised the submission of the claims.
But that's subject to point 4, isn't it? Which is that there's
yes.
Automatic EU law, stroke statutory,
Indeed.
stroke legal authorisation.
At the moment, I'm very much confining myself to sort of the agency
This
analysis.
is factual agent, de facto in the ordinary sense.
Indeed, right. Now, however, agency can arise in certainly one other situation, and that would be where a person purports to act as an agent on behalf of a principal, albeit that they are not at that point authorised, and then the principal ratifies the acts of the agent, and that will then retrospectively create the agency as a matter of consent. Now, I accept that in principle, those findings, in fact, do not preclude that analysis, because one could look at the Carlton letters, and the construction of the Carlton letters is a question of mixed fact and law. And one could, by looking at those, I suppose, form a view that Carlton were purporting to act as agent. I say, of course, that that would not be a proper construction, but in principle one could. But nevertheless, because that would be a question of mixed fact and law, one would be looking to see whether the first-tier tribunal made a clear error of law, and if, in fact, the construction that the first-tier tribunal appeared to put on these letters was one open to them, then that is not a point which can be challenged on the statutory appeal.
Well, wait a minute. I mean, a construction, obviously there's a factual element in the sense you have to find what you're construing, a document in this case, that's clear enough, or several documents. But once you've identified those facts, all the rest is law, isn't it? What it means is a matter of law.
Indeed.
And I think the argument against you would be we're in as good a position as anyone else to see what objectively it means.
Well, the construction of a document is, as I understand it, normally viewed as a mixed question of fact and law. It is fact what the surrounding circumstances are, and some of the words themselves may be facts. But ultimately, I accept the construction one puts on the document is a question of law.
Yes.
My point is, though, that where it's mixed fact and law, one is still looking to try to identify the clear error of law that the first-tier tribunal made when they construed.
Well, I mean, normally the first instance court finds the circumstances, it finds what the documents are, and if there are surrounding circumstances which are relevant, it finds those, which it has done, hasn't it?
Indeed, it has. Just to be clear, my lords, I'm not suggesting that this court is absolutely precluded from looking at the construction of the letters. I accept that that is open.
No, but you're trying to put a slight gloss by saying there's got to be an egregious or clear error, and I think the answer to the question is, as a matter of law, obviously we give respect to the views of a lower court, but in law there's only one answer to the question of construction once one's got the facts.
Can I move on, my lords, to look at what I identified at the outset as the first criticism that we make, and that is the paragraph 27 of the Extra Division's judgment at page 131. And it's very close to the start of paragraph 27 on page 131. The Exeter Division said, in the context of section 43, and in particular the structures and relationships required by that section, we are of opinion that a claim for repayment or crediting of tax by an individual member of the VAT group must normally be construed as a claim made on behalf of the representative member as embodying the group. So it's the word normally there that we take issue with, insofar as that might be thought to be putting some sort of presumption in favour of agency in that situation. And the reasoning then set out by the court is that otherwise the claim would have no meaning. The individual member does not pay VAT while it is in the group and is not entitled to any repayment of VAT. The only entity that pays VAT in that situation is a quasi-persona. The representative member is embodying the group, and consequently any repayment of tax must be due to exactly the same quasi-persona. This is so even if the literal wording of the claim is to the effect that repayment is sought by the individual member, because the context of section 43 makes it clear that the claim cannot be made by the individual member in its own right, nor can repayment be made to the individual member. Consequently, our literal interpretation of such a claim is plainly inconsistent with the scheme of the legislation. In that situation, we're of the opinion that the claim must be construed purposively. It's clearly designed to secure a repayment of VAT as a result of the trading activities of a member of a VAT group. And the obvious import is that the claim should proceed in the name of the representative member. Nothing else makes sense in the legislative context. Now, where we start with our criticism of that is in fact from the Extra Division's own analysis of the VAT group relationships. So, for example, paragraph 17, the end of that, at the bottom of page MS 124, leading on to 125. So the conclusion of the Extra Division at the bottom of page 124 is 2 lines up. Correspondingly, any entitlement to a VAT repayment in respect of trading activities during the period must remain that of the appellant as representative member. HMRC accept that. That appears to us to be inherent in the very notion of the representative members embodying the VAT group. All rights, obligations, powers and liabilities in relation to VAT are, so far as HMRC are concerned, those of the representative member and no one else, subject only to the joint and several liability imposed by the final part of section 431. So what the Extra Division are saying there, and we agree with, is that the rights, obligations, powers and liabilities of the VAT group are, so far as HMRC concerned, those of the representative member, no one else. And slightly further back, actually, in the judgment, paragraph 16, first, this is MS 123, beginning of paragraph 16, it follows that as far as VAT is concerned, the individual members of the group have no independent existence. They function merely as part of the quasi-persona embodied in the representative member. So the Extra Division was setting out what we say is the correct analysis, that the representative member embodies the single taxable person in UK law. And individual group members or former group members do not act in relation to VAT matters vis-à-vis HMRC. They're of no consequence. So far from there being a presumption that when something comes into HMRC from an individual group member, it should be viewed as being made by or on behalf of the representative member, we say it would be neutral. Because normally we only look into the representative member, with the individual group members having no independent consequence for VAT purposes. So we say there's no need for a presumption one way or the other when one is construing a letter that comes in from an individual member. But even if it might be thought that within an ongoing VAT group, if an individual group member, because of the close financial and organisational ties that must exist within a VAT group, that a letter from a group member must be seen to be where they're acting as an agent for the representative member. Our point is surely that is different in a situation like the present one, where we're dealing with a former group member. So Carlton had not been within this VAT group for a period of, well, since 2008, and these claims came in, had not been a member since 1998. These claims came in 2007 and 2009. The reason given for this apparent presumption at paragraph 27 is that essentially otherwise these claims have no meaning unless one construes this as a claim made on behalf of the representative member. Well, in our submission, that's circular reasoning. That presumes that the claims must always be seen as being valid whenever they can be. But that, in our submission, is an illegitimate mode of reasoning. One doesn't require it. One simply looks at the letters themselves and construes the letters with or without a presumption one way or the other. Now, my lords, in our written case, we made reference to three decisions of Lord Drummond Young on what he called ad hoc agency. Now, these cases were not referred to by the extra division, and they're not referred to in the extra division's judgment, but I want to just look very briefly at one of them, just because there may be an overlap here with the rationale that we've seen in paragraph 27 in the extra division's reasoning. It's the final case of these three. It's a case called John Sterling against Westminster Properties. It should be at MS 925.
Tab 29.
Pardon, my lord?
Tab 29, I think.
Yes, it's tab 29, my lords. The facts of this case were that the pursuer was an individual trading as an individual firm called M&S Contracts, or an individual trader called M&S Contracts. He entered into a construction contract in October 2004. Then shortly after, in November 2004, he incorporated a company which he called M&S Contracts Limited. And during the construction works, various documents proceeded in the name of the company as opposed to him as a sole trader. A dispute arose about failure to make payments to M&S Contracts. A notice of adjudication was served initially on behalf of the company M&S Contracts Limited, but that was challenged by the other contracting party on the basis that it wasn't the company that was a party to the contract. There was then a fresh adjudication, this time running in the name of the pursuer as an individual. He was successful at the adjudication, and this action was an action to enforce the adjudicator's decision. The defendants challenged the jurisdiction of the adjudicator on the basis that there had in fact been no dispute crystallised between the pursuer as an individual and the defenders. And the relevance of agency here is, we can pick up at paragraph 15 on MS 934. So paragraph 15 is a narration of what the defender's submission was. It says, the correspondence in July, August, September 2005 passed generally in the name of the company M&S Contracts Limited. Thus, the invoice for the sum due under certificate number 6, issued on 14th July 2005, was in the name of the company. Likewise, a letter of 19th August 2005 addressed to the contract administrators referred to in paragraph 3 above was typewritten on the writing paper of the company. For the defenders, it was contended that these documents and other documents which proceeded in the company's name should be read according to their strict terms. Because they proceeded in the company name, they could not affect the legal position as between the defenders and the pursuer as an individual. And then Lord Drummond-Young says at 16, if the doctrine of separate corporate personality is applied to its full rigour, the defender's argument is clearly correct. I'm nevertheless of opinion that this is too simplistic an approach. In commercial practice, it is not unusual to discover that the niceties of the doctrine of separate corporate persona are ignored, where, for example, a contract has been concluded in the name of an individual trader, but the individual then transfers his business to a company. It is frequently found that the correspondence after the transfer proceeds in the name of the company rather than the individual, despite the fact that it is the individual who is the contracting party. In such a case, if the correspondence is construed literally as proceeding in the name of the company, the result is likely to be nonsensical, as the company is not a party to the contract to which the correspondence obviously relates. That contract is in the name of the individual. In these circumstances, the only sensible inference, it's an inference, will normally be that the company in conducting the correspondence is acting as an ad hoc agent for the contracting party, the individual. That is, in my opinion, in accordance with the obvious intention of the parties. A similar inference can readily...
How far do you want us to read?
Sorry.
And we can read it to ourselves,
yes,
if that would be better. Where do you want us to read down to?
I do want to read just to the end of this page, I think. A similar inference can readily be drawn in cases involving a group of companies where a contract is in the name of one company.
Well, why don't you just let us read it? Yes, well, he goes on then.
So what's being said in paragraph 16 is there will be situations where there's an obvious inference of an ad hoc agency, and that is an obvious inference drawn really on the basis of the relationship within a company structure or a close ongoing financial business interest.
What makes sense of what's happening, yes.
Indeed. And the only other paragraph I'd like my lords to look at is paragraph 20.
Shall we read that to ourselves?
If my lords wish to look at that, because it's drawing a distinction between situations where ad hoc agency might be found and situations where it might not be.
Right.
So, my lords, what Lord Drummond-Young seems to be saying in this case is that there will be situations of actual authority where one can see the actual authority implied as an obvious inference from the relationship between the parties. The point I make 2 points. Well, first of all, assuming that is correct, there is no ongoing organisational relationship between Carlton, when they made these claims, and the original Taylor-Clark VAT group. That relationship had ended a number of years earlier. And the second point I draw from this, in particular paragraph 20, which my lords have just read, is that this inference of agency may be appropriate in relation to correspondence, but is not appropriate when a degree of formality is required, such as when one is getting into dispute resolution, including letters prior to litigation. And we are in that situation in the present case. So for these reasons, based both on...
So you're not challenging the analysis in this case?
No.
You're saying it supports your...
I say it
position.
supports it. So that's all I propose to say on what I described as the first issue. Our position is...
Was this case cited in the...
No, it's a slightly odd situation that I don't think agency was addressed to the Inner House at all. There were no agency cases put forward to the Inner House at all. So the Inner House's judgment is based on agency, but they weren't addressed on agency.
Wasn't in the written submissions.
No.
That might be interesting to just confirm, but we have them, don't we?
Mm-hmm.
So I think the note of argument for the hearing before the Inner House for the note of argument for Taylor-Clark is at MS 221.
Yes.
And certainly it follows what my own notes of the argument were, might be said a VAT approach rather than an agency approach.
Yeah.
Although I think you did characterise it in your response as envisaging that Carlton were acting unknowingly and unwillingly as a public agent.
Yes.
That's paragraph 18 at MS 17. But this wasn't based on any analysis of the common law, the Scots common law of agency.
No.
It was an inference taken from their presentation.
The argument seems to be based on EU law. At paragraph, well, the issues are identified at 29 to 31 on page 229. And it seems to be based on the EU law governing VAT groups.
Indeed.
How far is there any suggestion that there is a crack or a split between EU law and domestic law here? That hasn't been explored.
No.
I mean, there is lurking here some suggestion that a VAT group is, in EU law, a peculiar concept, and that idea might be thought to be slightly different from the way in which the directive has in fact been transposed in domestic law, which is to focus on the representative company and to attribute to it all the dealings of everyone else who's within the VAT group.
Yes, as I've indicated, my lord, I will come on to deal with that. What I'm trying to do at the moment is simply look at the reasoning of the extra division that, in a sense, I have to.
You're quite right. I'm taking it out of your way. Anyway, that's a point which we can deal with later. But,
so, perhaps I just can finish this section of my submissions by saying HMRC's position is that when one approaches the construction of Carlton's claims letters, one does it without any presumption one way or the other that there is presumed agency or presumed non-agency, if I can put it that way. The second main strand of my criticism of the extra division's decision is the approach to the construction of the letters. I'll take my lords, first of all, to how the extra division deal with this. The extra division narrate the letters, but I think just simply narrates really without any comment. Paragraphs 20 through to 22, which is at pages 126 to 128. And then they come back to actually look at or analyse the letters at paragraph 29, which is MS 133.
The argument's crystallised, at least in the submissions, on page 237. At the foot of a page, the argument runs that Carlton is the same as the VAT group for
Yes.
VAT purposes, applying an EU law analysis.
Yes.
And therefore, if Carlton submit a claim, the claimant, in terms of the regulations, is, as a matter of law, EU law, the Taylor-Clark VAT group.
Indeed. Yeah. That was the argument. My note is the way it was always put was that the group member, or indeed a former group member, was still in some way absorbed into the single taxable person. Yeah. So therefore, when they did an act, it automatically had to be seen as being for the single taxable.
So it's not based on a common law concept of agency. It's rather that because of the way tax groups operate in the context of VAT law, a claim made by any member of a group is, as a matter of law,
Indeed.
a claim by the group as a whole.
Indeed. And that is what I conceive is the primary position of the respondents in this case, in the written case. The difficulty I have is I think I have to deal, first of all, with what the extra division's reasoning is, and then perhaps come back to that further point.
Yes, it doesn't. I mean, let us assume that we do look at the EU law analysis and speak in terms of VAT groups. It doesn't mean to say that each individual member is even purporting to act as the VAT group if it makes a communication with the revenue.
Indeed.
It may perfectly well think that it has its own claim. At the state of prior to, in 2007, 2009, it appears to have been perfectly possible to argue that it did have its own claim.
And that's a very point I'm about to come on to when we look at the letters themselves, because contrary to what the extra division say that the claim has no meaning, we say when one looks at the letters, it's quite clear Carlton understood that they had their own individual claim, and they were trying to keep the claim out of the VAT group and making arguments of why it came to them rather than back to the representative member. So I was going to look now just at those claims letters, but before I do so, can I just take my lords to the reasoning of the extra division on construing these letters? It's paragraph 29. I'm not going to read it out, but the criticism I would make here, that when one looks at the reasoning there, the extra division very much focus on the headings of the letters, the VAT registration number, and I think the VAT periods. They don't discuss the text of the letters. It's very much based on headings, VAT registration number, and periods. And of course those points are relevant, but we say that when one actually looks at the text of the letters, they would fall to be construed as being claims made by Carlton on their own behalf. So, I wonder if I could take my lords just to those letters. They start at MS 372. So, between 372 and 387, there are 4 letters all dated on the 16th of November 2007, all making what are called protective claims, all on Carlton's paper, but from the finance director of Carlton. The terms are very similar in all letters. There's slight differences, but they're pretty similar in all 4 letters. And each letter has an attachment. And then there's a 5th letter, which is at MS 388. And this is a letter, again, from Carlton to HMRC on the 8th of January 2009. And it bears to amend one of the earlier letters, the figures in an earlier letter, and there's the text of that letter in particular I'm going to look at. Now, there are a number of, I think, points which are undisputed. First of all 5 letters are on Carlton's headed paper. They're all sent by Carlton's finance director. None of the letters expressly say that they're sent on behalf of the Taylor Clark Group. The first 4 letters from November 2007 refer to our claim.
Sorry, page.
They refer to our claim. So if one sees, I'm looking at page 373, for example. I think it's 3 lines down. Talks about if our claim is proved successful, and I think the same appears in all the letters. Yes, and I'm also reminded the second last paragraph talks about acknowledgement of our protective claim.
Well, it looks as if there's been a bit of legal input into these letters. The reference to our client
Yes, that
suggests something.
indeed.
Yes.
Yes.
It suggests a lawyer who's cast his eye over it or has drafted it on
Or
behalf
a bit of cutting and
finance.
pasting.
Drafted the original draft, I think, yes.
There's less.
Indeed, my lord. And what's also common to, I think, all letters is that Taylor Clark's registration number, the group registration number, appears in all of them. There's one slight difference.
You mean its company registration number?
So
It's VAT.
the VAT registration number. So if
Yes.
one sees 265791816, that's the VAT, Taylor
Yes,
Clark's
yeah.
VAT group. There's one difference.
Tell me, when you say it's the VAT Taylor Clark Group, in the light of the domestic legislation, it's presumably, just the representative companies.
It's a
that
the
number.
representative members
Yes.
number.
I suppose, is it possible that somebody could have 2 VAT registrations, one as a representative company and one for other purposes? Isn't
No,
it?
I
you
understand.
have one VAT registration.
I'll check that. I understand you can only have the one. Yes, a company can only have one VAT registration number at one time. One can't be in a VAT group but also have some sort of external VAT
No,
group.
I think personal experience from the bar confirms that one used it for everything.
Indeed.
Yeah.
I was just going to point out there is one difference between one of the November 2007 letters and the other 3, in that the very first letter at 372 has Carlton Clubs PLC in the heading, whereas the other 3 have Taylor Clark Leisure Limited in the heading. One of the points which isn't discussed by the Exeter Division but might be thought to be at least of some relevance is that the 4 November 2007 letters all refer to previous claims submitted by Carlton Clubs.
Yes, I was going to ask about that. I mean, do we have those?
No,
I
we
couldn't find
don't. Those were never before the FTT. Of course, Carlton weren't part of the litigation, so
It seems to be common ground that that's probably the case, looking at the respondent's argument, but they say that these letters are distinct and represent a change of direction.
well,
That's
those
the point of
letters.
the letters, I think they're saying.
I think it's a fair inference that those letters relate to the period after Carlton had left the VAT group,
And would have carried a different
where they would have their own VAT registration
Exactly.
number and would have their distinct.
Oh, yes,
claim.
I see. Yes.
So the only point I see seek to make from that reference is that at least Carlton are submitting that this just follows on from other claims which undoubtedly went to them. But the really key letter in my submission, which we need to look at, is the 8th January 2009 letter, which is at MS 388-389.
Yes, you'll be saying presumably that informs what they were doing earlier.
Indeed.
Because we see they're reliant on the assignation.
Indeed.
For example. Yeah.
Absolutely, my lord. So this letter bears to be an amendment of the letter which is at MS 384, it's APM and participation fees claim. And we see this time both company names are in the heading, in fact, both company numbers are in the heading. And the really crucial part in my submission is the paragraph headed "The right to deduct" on MS 389. Because this paragraph is setting out why Carlton are saying these are their claims personally. Because in the second paragraph there that starts the asset transfer agreement, it's referring to an agreement from 1990 which took place between CAC Leisure Limited, that is Taylor Clark, and Leisure Bright, that is Carlton. And what is being asserted here in that paragraph and then the fourth paragraph under right to deduct is that Taylor Clark have assigned their right of payment for the period from 1973 to 1990 to Carlton. So Carlton are making a claim as assignees, not as agents, but as assignees. And then, in the third paragraph under right to deduct, the longest paragraph there, Carlton are setting out why they say they get the claim from 1990 to 1996 or 1998. I can't remember what they're claiming for at this point. 1996 by this point. Because what they're saying there is that although they were a member of the VAT group, they came out of the VAT group, and they say on the basis of a case called Triad Timbers, the rights to make the claims remain with the legal entity, and therefore they're entitled to make the claim. What they mean by that is they were contending that because they were the party that actually generated the VAT between 1990 and 1996, sometimes called the real world supplier, when they came back out of the group, they took that VAT repayment claim with them. Now, it may well be that for those two periods, as a matter of law, they were wrong. First of all, the upper tribunal, although the first tier tribunal accepted that the assignation was valid, the upper tribunal didn't. But the point is, whether they're right or wrong, this was their contention that they had the right to claim for 73 to 1990 as assignees, and from 1990 onwards, because having left the group, they took the claim with them. And it may be that, in retrospect, we think those contentions are odd now, but one has to put this in the context that there was no case law by 2009 yet about parties leaving VAT groups and what rights they took or didn't take with them. In relation to a Section 80 claim, I should say. So, my main criticism of the extra division's construction is that they did not look at the text of these letters, and in particular the text of the 8th January 2009 claim. Now,
is there some principle that enables us to construe the earlier letters by reference to the later ones?
Well, it's quite clear that the later letter is an amendment to one of the earlier letters. It's an amendment to the claim. And the earlier letter, of course, was said to just simply be a protective claim which would be revised. I think the letters say at the end that they will revise their calculations later.
It only relates to one claim, doesn't it?
That's correct, my lord.
104. So, I mean, let us see it as an amendment to that claim. That may mean that there is no longer any claim being made purportedly on behalf of Carlton Club if the original letter was to be so construed. But it wouldn't affect the meaning of the other ones, would it?
Well, in my submission, it would. One is asking the question here. These letters have to be construed really, I think, as a whole, which is the way that they've been construed in the past, to see whether Carlton are purporting to act as agents. What is being said in this last letter of January 2009 is common. It's not particular to the AP and participation fees claim. They're saying that these are general points about why they say they're entitled to the VAT. It's not.
I mean, I can understand them as background points. Common thinking at the time was that when a company left a VAT group, it acquired the right to claim so far as it had the underlying economic interest. That's a perfectly legitimate aid to construction of all 4 letters in 2000 and whatever the date of the previous letters were, 7. But does it go further than that? I mean, I certainly in English law, I have some hesitation about the proposition that you can construe a November 2007 letter by reference to a January 2009.
Well, the way I would put it is these claims had to be in by a particular deadline. I think it was the 31st of March 2009. So, and claims are commonly put in and then go through a process of refinement and amendment. That is what's happened here. So when one comes to the end of that time period and one is asking the question, now these claims have to be considered, are Carlton acting as agent or not? One can look at all of the claims together, even though the 2009 letter does not, in terms, amend 3 of the earlier 4 letters.
So one looks at it as at the 31st of March 2009.
That's
and as these are concerned with the act of the same subject matter, you're entitled to look at them as a group to see what they mean.
That's the way I would put it, my lord.
But why should the long stop date be relevant at all here?
Right. I mean, you don't normally construe a document by reference to a later date. Anyway, I mean, I think what I'm interested in, is there any special principle? Does Scots law take a more relaxed attitude to the use of subsequent evidence than English law?
No.
I mean, surely what matters is when the revenue actually do something with these.
It's when the claims are being considered.
And when they deal with them, then they obviously take the material they've got before them. And I would have thought you could look at them together at that point.
Indeed.
There's no sort of rule that you can't.
Your point really is they're construing, we and they are construing not individual documents, but claims.
Indeed.
Which are to be found in a number of documents.
Indeed.
It's an easier case in relation to the
2000
participation fees claim.
Indeed.
It is in relation to the other 3, but I understand your point that the basis on which Carlton assert beneficial ownership of the claim in that letter is purely general. It relates to all output tax previously declared in relation to the pre-1990 period, and just generally to the triad principle thereafter.
Yes, it's the assignation for the pre-1990 and triad after. That's right, my lord. So, as I think I set out at the start of this particular chapter, my criticism of the extra division is that they didn't consider the text of these letters. Rather, they focused on questions of headings,
So basically, that's the second point.
That is it. And
So
my lord's
they weren't written, any of them, objectively, when you look at them.
Indeed.
A fortiori in respect to the participation fees letter.
Indeed. And if my lords are with me on that, that would mean that there is no scope for the argument that Carlton purported to act as agent, and one doesn't get on to questions of ratification, for example.
Right.
I'm not going to say very much about ratification because we discussed that briefly in the discussions earlier. My criticism here was, though, that the extra division failed to realise that if their analysis was based on purported actions by Carlton as agent, purporting to act as agent, then one required ratification. And I think, my Lords, of my submission that the problem with that is there are no findings in fact that go to ratification.
I don't think the extra division didn't see it as a purporting to act.
No.
The extra division saw it as, in some way, not only purporting, but actually having authority by statutory means or whatever.
Indeed. And I say, on normal agency principles, one can't see agency arising here through the granting of authority by the principal and the acceptance by the agent. So one falls back on purported authority, followed by ratification.
Yeah.
So on this point, there is some discussion. Well, I'll come to that in a minute. The first point is simply the point that we say that there's no findings in fact relating to this. The respondents in their written case say, well, it's clear that there has been ratification, but in my submission, it is not clear on the facts that there's been ratification. And I'll just refer you to one particular section in the Upper Tribunal's decision. It's paragraph 17, MS 307.
Did you say MS 307?
MS 307, it should be paragraph 17.
Yeah.
And this is just a narration of the argument on time bar issue for Taylor Clark. And you'll see there, my lords, that it was accepted the claims were made by Carlton had been submitted on Carlton's behalf and not on behalf of the appellant. Now, I just pause. If that's the position, then one can't say there has been clear ratification.
Well, maybe they say there has been now, but because they're certainly claiming to rely on anything that was purportedly done on their behalf now, but there are principles about timious ratification, aren't there, as well as other things? I haven't got them.
Yes,
in mind,
I think it's slightly controversial. There's a question whether Scots law requires within a reasonable time. I think English law does require it within a reasonable time. And there's also a question about whether one can ratify after the expiry of a time bar.
Yeah. Well, those are interesting questions.
They're interesting questions, and they're questions which clearly would take far more than one day before the Supreme Court, and we don't even have all the authorities on that.
I wouldn't be sure about that.
The latter point has not been argued for any Scottish tribunal below this court.
And I accept that. So I'm not going to make a submission in relation to time bar, because I don't think my lords could properly deal with the question of ratification, whether it can take place after time bar, simply because we don't have any decisions in the court, any reasoning of the court below. Yeah. We have no findings in fact, and we simply would not be able to get through all the authorities in an hour or two.
But you say in any event, at least until the upper tribunal, by which time we are merely dealing with questions of law, the position of Taylor Clark was that the Carlton had submitted claims on its own. So there is there to be facts found to the contrary.
Indeed, yeah. Now, my lords, I think those deal with...
Could you just give me a moment? He's done with them to some extent in his case. And come back and reply. That's true. we're just wondering how satisfactory it is, but I think the answer is that we'll hear what your opponent says, and you made the choice to deal with it in this abbreviated way. It may rebound on you, and you will certainly have the opportunity to deal with it in reply if it. I don't think you can take it that we're simply accepting at the moment that it's out of the arena for the reasons you've mentioned, because we've got to hear your opponent Indeed. On it, and it has been touched on in the written cases.
Indeed.
Yes. Thank you very much indeed. Mr. Thompson?
I have nothing to add.
Thank you. Yes, Mr. Simpson.
My Lords, the respondents would propose that my friend Mr. Scory make submissions on the first part of the case, which concerns the EU law issue, and then I shall thereafter make submissions on the general Scots law agency ratification issues.
Thank you. Yes.
Well, if I may deal with the first of the two core propositions set out in the respondent's written case, we do say, as we said below, that the extra division was correct to conclude that the claims made by Carlton were purely for fiscal purposes to be treated as claims made on behalf of or attributed to the single taxable person, who is normally represented by the representative member. Now that will require an analysis in the context, and that's important, in the context of that grouping, of the terms of Carlton's letters and the validity of those claims, given their nature, pursuant to Section 80 of the VAT Act. Mr. Simpson will then deal with the issue of whether, if they're not treated as a matter of law as valid claims in my client's hands, whether they can nevertheless be ratified or otherwise adopted. And that distinction that you've been discussing with my learned friend Mr. Young arises from the approach of the extra division. If I could ask your lordships to turn to MS 130, paragraph 25 of the decision below. One sees at the beginning of that paragraph the conclusion that a claim can be advanced by somebody other than a representative member. If one drops down 10 lines or so, there is a sentence: for present purposes, it is the signification of the Act for that purposes that matters, rather than its import under general law. In my submission, that's right. I'm going to address you on the issue of its signification for that purposes. And my learned friends go on to criticise the extra division for how they have then pigeonholed those consequences under the general law. It's going to be my submission that doesn't matter. What matters is what is the proper treatment of these letters in the public law sphere of a claim vis-à-vis an individual and the state. But if I can turn to that, I'm going to go back in a moment to the claim letters, because I think it's common ground between the parties. Those must be construed objectively. We say at the time submitted. And if one looks at them, I'm going to submit it's clear that what they are doing is asserting, for fiscal purposes, a claim which belongs to the single taxable person. The only point in time when there's any intimation of the juridical basis on which it's said to be payable to Carlton is in the revised claim in 09, referable only to the participation fee. And in response to my Lord Carnworth's proposition, does one look at it at the time the Crown deals with it? Even if that is right, the Crown's response was they paid the money to my clients because they used my client's VAT registration number. I should stress a VAT registration number that is not peculiar to the representative member. That is a VAT number that is peculiar and personal to the single taxable person, because the representative member can change from time to time but the number always remains the same. It doesn't change depending who is the member, which is very different from normal VAT numbers, which represent the ongoing VAT account between the taxable person and the state, which is specific to the individual. Here it is not. It is individual to the collective group, no matter who is put at the point of interface between the taxpayer and the state, as embodied in the representative member. Before I turn to those claims, could I just set out my stall on the principles applicable to VAT groups, which, as my own friend said, is largely common ground. The following propositions should not be controversial, which is that single taxable person, for fiscal purposes, does not have a legal persona as a matter of domestic law. It is a legal fiction. Instead,
Well, that's difficult to accept, isn't it? It depends whether you look at it in what I think you say is the EU law way, or whether you look at it in the domestic law way as the directive is implemented. The domestic law way does take a legal person, but attributes to them various acts which they haven't actually done, like supply goods to third party or buy goods. But nonetheless, for VAT purposes, it is the representative company and the representative company alone who, to whom all these acts are attributed and which is dealing with the revenue. So it is a single taxable person. It's just attributed with various acts. So there isn't, in domestic law, it seems to be floating around this ethereal concept of a single VAT group dealing with the revenue. That's not how domestic law is structured.
if that were how one were to construe Section 43, then it may well be that Section 43 is not compliant. And I would urge
Why? We have some discretion as to how to implement the VAT directive. What has anyone ever suggested that the domestic VAT law is not fundamentally not compliant in this respect?
No, because it's not been suggested in my law that the rights of the VAT group, as it were, coalesce and are vested beneficially and solely in the representative member.
I think it has been suggested. I think that's the whole basis of the case against you, isn't it?
Well,
I mean, I appreciate that this case seems to have changed shape at every stage.
It has
but,
changed shape.
We're now focusing on the case which has advanced here.
It's changed shape as the views on the nature of VAT grouping have evolved. And that's not just in this case, but in litigation still going on below in the MGR Standard Charter litigation. But even in that case, one sees Mr. Justice Warren in the tribunal talking about the rights being owned by the members of the VAT group on as it were, a commingled basis because they are the single taxable person.
Well, I mean, if he's talking about that, then I don't recognise the language, and you better refer us to it. But it does seem to me that nobody has challenged the consistency of the domestic implementation of VAT until now, and on the face of it, I think we should start with the domestic legislation, and we'd have to consider seriously how far it can be suggested that it's inconsistent.
Well, if I may, my lord, in this arena, one should start with the European position.
Yes, well, Article 11 empowers member states to regard as a single person persons which are legally independent but are closely bound together.
Exactly.
So it's an empowering rather than a compelling provision. In the UK, the invitation has been taken up, if it has, by Section 43, which treats the business carried out by members of a group as being that of the representative member. I mean, is there any question of incompatibility here?
Well, in my submission, there is not, because one construes Section 43 to give rise to a single taxable person constituted by their members, embodied in the quasi-persona for fiscal purposes in the representative member. Because if one starts, as my Lord Hodge does, at Article 11, what the empowering provision, so it's not directly effective.
Where have you, my Lord's got Article 11 on the screen.
In the authorities,
470.
tab 7,
It's
MS 470.
MS470.
Right, yes, thank you.
Very brief provision.
Are you going to tell us at some point in what capacity Carlton holds the money that it was paid?
Well, if that point had been a matter of appeal, then I might need to do so. But I will, my Lord, because actually it doesn't arise on the Crown's argument, because they accept they get good discharge of their fiscal obligations, their public law obligations, by paying the representative member. That's their case, and we accept it. They haven't done so. And even if one were to go down a route...
I'm sorry. You say they haven't done so?
No, they haven't paid.
The representative member?
No, they haven't.
So you say that you can claim, but yeah.
And you say you...
And just to be clear, my Lord, when the claims go in 07 by Carlton, and the revised claim in 09, and we're made aware of this because, pursuant to the terms, we're paid it, and we say, hold hard, can we have all the others, please, too? And the answer comes back, no. Then before Carlton are paid, as far as we can deduce, we battle fiercely to say we are the correct payee. There can be no doubt in the minds of the Crown, or indeed Carlton, as to who we said was entitled to the payment. Indeed, you will see from the...
Sure, but on your own argument, why is it only you? On your own argument, it's the VAT group, which is includes Carlton. So what's wrong with the payment to Carlton and as a payment to the VAT group?
Because if it's a collective right, it can't be discharged. Put aside my objections a moment ago. And put aside the Crown's position, which is they get good discharge by paying the representative member and no other. If it's a collective right, it's paid to the collective. That is done so by dint of paying the person who the collective says pay it to them, the representative member. And it may be one doesn't need to get into issues about what is the model for domestic law, of how one deals with these rights of the collective standing behind the representative member.
Are you arguing then that Carlton can make the claim effectively, but if they, for the benefit of the group, but if Carlton are paid out on the claim, they don't have any obligation to account to the group for the payment?
Well, that's, as it were, a private law issue which isn't before your lordships. And even before we get to the private law issue of their obligations, as it were, behind the veil of the fiction, the first point is that when the claim goes in, and I'll go and show your lordships why we say the claim was that of the single taxable person, when it therefore, because the Crown refused it to both parties, so we're not paying anybody, we then said, the current collective, pay the representative member. So to the extent one is looking at the collective who holds the right, there's a very clear instruction to the revenue authorities. Don't pay the person who's made the claim. They are no longer part of the collective. Pay it to the representative member. And that was ignored. And interestingly, the reason why there's a dispute here is you will see from the statement of facts that although they paid my clients the last of the claims, and there was a dispute as to whether or not that was payable, later the next year they said, yes, actually, the monies are due to your clients. However, because of the competing claim by Carlton, we will just maintain in force a protective but assessment for the amount of a clawback. Now, they could have done exactly the same thing vis-à-vis Carlton. Indeed, that is a position which happened with the litigation with MGR. So it's to protect their position, to claw it back, and they didn't do so. And they're now facing a position where they accept the monies were properly payable to my clients, but they happen to have paid them to somebody else and they can't get them back. That is the situation, not of my client's doing. And what,
Maybe not, but at the end of the day, your client's claim rests on Carlton's claim and construing Carlton's claim as a claim on behalf of the persona, the EU persona. Now, if that is correct in law, then Carlton's money is the money of the group.
Surely.
but
Because they've been paid out in respect of a claim which you say is a claim on your behalf.
I would draw a distinction, my lord, between the money being the money to which the group is entitled and it having been therefore paid to the group, and they are not the same things. Because yes, it was indeed the group's entitlement, that is common ground, but by paying it to Carlton, a party who at the time of receipt was asserting a personal entitlement and disputing the group's entitlement, which is common ground, it's difficult to see how that can be said in the mouth of the Crown to be a satisfaction of the competing claim by my clients when it's received in the hands of Carlton expressly not on the basis of a payment to the single taxable person.
So a claim to repayment by Carlton is a claim by the group, but repayment to Carlton is not repayment to the group.
Yes, my lord. Yes. That will be my ultimate submission, in the same way that there can be a claim by the group by one alone.
And yet the only basis for Carlton's claim is the timeless, are the timeless claims which you say were in fact your claims.
Yes.
And you say Carlton is under no obligation to account to you for the fruits of what you say were your claims.
Well, it may well be, and I reserve my position on but that's a private law matter. I am here on.
But it's, I mean, I find I can see how you say that, but it seems to be terribly difficult for us to analyse the nature of the claims without also analysing the nature of what happened to the money, because they seem to be inevitably very closely linked. I'm trying to sort of separate the two.
Well, that will require your lordships then to devise a domestic law framework to impose upon the relationship between members of a VAT group, which isn't currently there in law. For example, it could have been implemented whereby those in a VAT group have to form a separate corporate entity in which resides the rights. There could have been some form of partnership model. There could have been some other vehicle known to the laws of other member states, which would hold the rights and maybe apportion the rights between the parties, such that payment to one was deemed under the local law to give good discharge vis-a-vis the others entitled. There is no such framework under Section 43.
But on the inner house's agency model, then it's very straightforward. The agent accounts for the money.
Well,
I mean, on your sort of EU-based model, then I can see one's got to sort of construct something.
If I can try and have the best of both worlds,
Yeah, I can see.
I adopt the agency model to the extent I need to, but only so far, in the sense that by making a claim, and one goes beyond its signification for VAT purposes and has to apply a domestic law label, what is the legal effect under domestic law of the actions of Carlton, then it may be one has to say, as an agent. It doesn't then follow that payment to that agent is satisfaction of the claim, because as at the time of payment, well, 2 points. First, as it were, adopting that claim and the authority to make the claim does not entail authority then to pursue it in litigation and receive payment. But if ever that were in doubt, by the time there was payment, nobody was under any misapprehension that we wanted the payment to be made to that erstwhile agent for these purposes. So the agency point doesn't help the Crown, even if one goes down it, because any authority had clearly been terminated by dint of the fact that the parties were engaging in what was in effect an interpleader action in the Edinburgh Tribunal. Because the parties had joined their two claims, because both were asserting, I should be paid this.
But on the agency analysis, there's a continuing agency by Carlton on behalf of the group. for the purposes of claims relating to the period when it was a member of the group. And the implication of that analysis, I think, is that the group has been paid twice because because TC have received the money, Taylor Clark have received the money, but also the agent has also received the money and holds it to the account of the group.
If I may, I'll come back to your lordship as to whether, on the facts of this case, one can say that, because it may be because of time-limited passages of time that private law action is not open to my clients, and therefore, if one says, has the group actually, can it recover it? The answer is no.
Well, you might be out of time, I don't know, but but looking at it from the revenue's point of view, they can't be expected to pay the group twice over.
No, but they weren't purporting to pay the group at all, because
No, but on your argument, well, the argument would be against you, but on a common law agency analysis, payment to Carlton was payment to the group.
If it were not clear that agency was either limited or terminated, that would be right, my lord.
You presumably say it was terminated from the moment you said, pay us, don't pay Carlton.
Exactly. And that could have been, in no doubt, when both parties cross-applied to bring each other into their own proceedings. And it was only because the Crown paid Carlton and they withdrew that those proceedings didn't proceed on a joint basis. Otherwise, you'd have both parties here before your lordships.
Yes, but it does draw into question, which we'll be hearing later from Mr. Simpson, the idea that there's been any ratification, because the truth is that at least until the upper tribunal, there was no assertion of agency whatsoever by Taylor Clark.
No,
so whether there's a certain artificiality analysing these matters as ratification and withdrawal of authority when no one was thinking in those terms.
My lord, that's right, but we are here thinking about it in those terms, and the facts are not in doubt, and therefore we're simply applying a legal framework to what is factually common ground. And I don't want to steal Melania's friend's thunder when it comes to agency and ratification. But what is clear is that from the very start of the dispute, we relied upon the Timaeus claims by Carlton. We did not say, we hereby ratify that made by an agent, but there was no mistake. We said, we are entitled and we are in time because of the claims by Carlton. Now, that may not have had attached to it contemporaneously the label ratification. It's simply now we're trying to apply a label to it. But if one needs to do so, my submission, it fits perfectly well. But we have moved on slightly from where I began a few moments ago. Forgive me for the digression, which is the nature of the VAT group. We went, my Lord Master, to tab 7 of the authorities bundle. And what the permissive right of a member state there is not to ascribe supplies to a single member. It is to treat persons as a single taxable person. So it's to treat a number as a single group. That's what it's supposed to do. Now, section 43, as your lordship's already pointed out, tab 2, does that, possibly in a rather simplistic way, although mechanically for most purposes it works, which is just to ascribe all the supplies to and from the group to the representative member. And therefore, in terms of the rights and liabilities on a day-to-day basis, that in many respects, that achieves the same purpose as treating all the members as a single taxable person.
But it is so by a different mechanism.
By a different mechanism, although the effect is the same, and in support of that proposition, if I could ask your lordships to turn to tab 16 of the same authorities bundle, which is Thorne in the House of Lords,
Age.
MS 623, at letter E.
Tab, yes.
16.
623, yes.
There's a reference there, letter E to section 29, that's the predecessor, but in the same terms as section 43. It was to enable a group to be treated as if it were a single taxable entity.
But where is the, which line?
MS 623.
Yes, which line?
Letter E.
E. Okay. Yes.
So the group is treated as the single taxable person, not simply the representative member. One can't equate
Well,
the two.
that's where I have a difficulty. I mean, you are effectively, I don't know whether it's a matter of Marleasing construction or what, combining or treating as one what seem to me two slightly different approaches. And earlier you were saying, well, maybe the domestic approach is inconsistent with EU law, but that seems to me quite a radical proposition, particularly as I think Article 14 says that you may treat people as a single tax person after taking the advice of the VAT committee, which is a committee with representatives of member states and of the Commission, and I'm sure that was done, and I'm sure that they must have approved or must know very well about the UK legislative scheme.
Well, if your Lordship's trying to put to me that because there have been no infraction proceedings, one presumes it's valid, I'm not sure that I would accept that proposition. But I don't need to go that far, my Lord. Your Lordship put to me the notion that the single taxable person is the representative member.
Yes.
And all I say in response to that is that's not how one should approach it in the first instance. One looks at it through the fiction, the prism of Article 11, which is one treats the persons as the single taxable person.
I don't see how we can do it consistently with domestic law. We've implemented the European law in one way. We've either got it correct or not, but I don't see that they're easy to reconcile here by the sort of Marleasing gloss.
Well, maybe Mr. Prosser is more successful with Lord Nolan in Thorn, where, as I've shown your Lordship...
Well, Lord Nolan is looking at the matter very generally, but he's not faced with the particular problem we are faced with.
Well, I'm going to take you in a moment, my Lord, to the European authorities. But
I mean, your proposition does involve something which seems to be radically different from what the revenue would probably, or anyone would probably expect from Section 43, namely that far from dealing just with the representative member, any member of the group can pop up and make a valid claim on behalf of the group, and the revenue may receive 5 different claims in respect to the same subject matter from different members of the group. Well, that's a pretty radical proposition, isn't it? We've got one exception to the proposition that you look at the representative member, namely that is the provision for joint and several liability of all members of the group for anything which the representative member is liable for. But that exception itself points to the general rule.
To answer your Lordship's extreme example, it doesn't happen in practice with an existing group, but by dint of the very nature, either of its size or of the level of control which is the necessary predicate for there to be a group. So there aren't going to be 5 competing claims because they are treated as a single taxable person because of the level of corporate control within them to stop that very thing happening. But one should not therefore think that the only interface between the revenue and the single taxable person is that representative member, because that is simply not the case. I'm sure all at the bar have experience where there may be a head office which is the representative member of the single taxable person. And there's a claim, and let's give a concrete example. Imagine a bank with a rep member in London, and there's within the VAT group, there is a little IT company in Cardiff which has a very small claim. Now, any questions going to head office, they'll have absolutely no idea what's going on in the office, and therefore the claim goes in and is dealt with, and the interface between the taxpayer and the revenue is with the Cardiff office. And there's no difficulty, because although that letter may be Cardiff office and their separate legal identity, the critical point is that the VAT registration number is of the group. And that is the key, because that signifies they're dealing with the group, not individually. And therefore there's no danger of double payment or double claims, because in terms of the VAT account between the Crown and the single taxable payer, they have the number, they have the right account, they can see what claims have been made. The issue only arises in this extreme case where one is dealing with a member who has departed. And therefore, for hitherto, the issue hasn't arisen, and no doubt not worthwhile arising, because one's not been concerned with these long-tail claims because of Fleming, where limitation periods have been brought back. But if I can stay for a moment.
The particular problem arises, doesn't it, because there's a mismatch between the period in respect of which the claim for repayment arises when the members were all part of the same group, and the period when it's being negotiated, asserted, discussed, and possibly even compromised when they're not.
Yes.
And it's at that point that the ghastly prospect of having any number of different former members of the group shouting at the revenue and saying, I'm asserting this or that or the other, and actually I'm prepared to bargain for this if I can have something back in some other respect.
Yes.
It starts to require one, doesn't it,
Yes.
to look at Section 43 in a way that makes it work.
Exactly, my lord. To give another concrete example, if one takes the Crown's argument to its extreme, the nominated representative member has all the rights and obligations to the exclusion of all others. But that is not the Crown's position, because the Crown recognise that an assessment can be made against a representative member, and in Section 43 is joint and several liability. In a case called J&W Supplies, a first-tier tribunal decision of back in...
Sorry, this is an assessment on what? On all the members of the group?
On the representative member.
On the representative member, yes, for what?
For VAT due to the revenue.
Yes. So what's wrong with that? That's consistent with the revenues case, isn't it?
Yes, but the issue in that case was that member had been wound up.
Yes.
And the liquidator hadn't issued an appeal. And the members of the group, on my submission, members of the single taxable person, sought then to appeal that.
Well, they sought to intervene, did they, or what?
No, they didn't intervene. They began the proceedings because the person to whom the assessment was addressed didn't do so because it had been wound up.
We better look at the case.
Tab 20, MS 707. And if one looks at paragraph 2, but starting at page 708, and then if one looks on at paragraph 15, when there recalls the Crown's submission. And again at paragraph 19, and those arguments are rejected by the tribunal at paragraph 26.
My
Lord, yes.
But they had, the commissioners had served notice on all the members of the group relying on their joint and several liability, hadn't it?
Yes, but in my submission that need not have been so, because they would, as a predicate to that, nevertheless have been able to challenge the initial assessment prior to any further notification to them. And that point appears to be made good from the Crown's own guidance issued to taxpayers, which is at tab 40 of the Authorities Bundle, MS 1074. Which makes a very short point that who can appeal against a decision or assessment, and under that third bullet point, one or more VAT group members. It's not confined to the representative member.
Now, that may just be an application of that case.
Yes, I'm simply just saying that that's the guidance issued. It's not said by the Crown it's wrong. If one looks in, and one can take this one of two ways, in the first tier tribunal cases, there are those where the person challenging is not the representative member, it may be a group member. There are also cases which demonstrate that there may be communications with, as it were, the real world supplier who knows the detail, and weighing decisions letters are referred to. My point is simply that to say that the single taxable person is to be equated with the representative member and everybody else is ignored for fiscal purposes simply isn't right. That goes too far.
Where do we have the appeal provision then? I mean, what does the appeal provision say about who can appeal?
Section 83 is not what we have. Is Section 80, which is the ability to.
You say it's Section 83, do you know?
Yes. I can back to your Lordship on that, if I may. Could I just, and forgive me for labelling the point, could I take your Lordships to the European jurisprudence, which in my submission makes clear that far from simply bestowing the single person status on the allocated representative member, the effect of Article 11 is to group together those which would otherwise be separate. Put another way, grouping has the effect of taking related companies and maintain their independent legal persona. It's not the same as a business which is one business but different divisions. So for private law purposes, they're separate legal companies, but they lose their independent fiscal persona. For example, they lose the right to have a VAT number. But what they do is they gain the collective persona of the single taxable person. And therefore, they all share the same VAT registration number, even though with 100 companies in the group, each separately incorporated, each with their own letter paper, each completing contracts on a daily basis, they will all use the same VAT registration number. And that is irrespective of who happens to be, at that time, the representative member. Could I take your Lordships first to Ampli Scientifica? Now, that is at Authorities, tab 34, 989, and that was the second little clip of Authorities that was sent in because they were misphotocopied. And there were issues in this case which needn't detain your Lordships about whether Italy had in fact brought in provisions which were meant to create a single taxable person, whether they consulted with the VAT committee. Those aren't relevant for present purposes. If I could direct the Court's attention to paragraph 19 on page MS 995.
Where are we looking?
Paragraph 19, my lord. I regard your lordship's
That
note.
rather looks against your primary submission, doesn't it? Because I thought you were saying that by virtue of being part of the single taxable person, any member of the VAT group can make claims to repayment, do things on behalf of
Yes.
the group. Revenue's got to take notice of it.
Yes.
Whereas this paragraph seems to be saying the exact opposite.
My lord, no, this paragraph says that a member of the VAT group cannot submit a declaration separately, i.e. for itself. It does not say a member of that single taxable person cannot submit a declaration for the group. Indeed, it presumes it can do so. Somebody's got to submit the return for the group.
Yes, but I mean, what are we talking about? If we are looking at that question, we have to look at it contemporaneously. And at the time, you yourself have referred to a case which indicates that it was thought that a former member of a tax group could submit a personal claim having left. That's a triad case.
Triad, yes.
Well, if that's the state of mind, then the fact that a member makes a VAT claim doesn't help us as to in what capacity it was making it, if it's a former member, which your clients were, which Carlton were.
Even if I can digress for a moment onto triad, the premise of triad was that there is a right which belongs to the single taxable person, that is to be exercised normally via the representative member. On disbandment, that right which belongs to the group in some way devolves back to the real world supplier. So it's still the right of the group that now can be exercised independently. So it's still the group's right that is being exercised, albeit that Carlton's saying, and I am entitled to be the recipient.
Yes, well, that's then it's a claim by Carlton, not by the group. Maybe that it's as an assignee or in some way a recipient of what was formerly the group's right, but it's the leaving member's right.
Well, I think there's a difference there, my lord, between being an assignee and claiming, and there's a danger of going down the rabbit hole here, because we're dealing with a situation which we all accept is the legally wrong situation. But what was asserted via triad was not an assignment, which is anybody could have taken a right from the group, I mean, unconnected with it.
It's a sort of devolved right, which
yes.
Is, but it's now, I mean, once it's devolved, it is the right of the company to whom it's devolved.
Well, again, but it was the right of the single taxable person, and because that group no longer exists, it was thought that the group's right could now be paid.
No, I don't think. I think surely triad's not a case of the group ceasing to exist. It's a case of someone leaving the group, isn't it? Have I misread it? I think your written rounds make the same point, but I didn't read it that way. I may be wrong.
Yes.
Where is this?
It's at tab 32, page MS 964.
Yeah, I mean, if you look at the foot of 966, yes. To require a company to act through the representative member after it's left the group must be at least inconvenient and likely to produce injustice and so on. It seems to be dealing with circumstances where a company has just left the group, isn't it?
Yes. and therefore asserting that the rights which previously were held, the bad debt relief claims that were held collectively, could then be enforced independently, although, as is common ground, that is wrong. They remain with the group.
Yeah, well, its common ground is wrong, but it seems to be the thinking at the time, including Carlton's thinking. It's referred to in their 2009 letter.
Yes.
Yes.
Yes, it was.
Right, sorry. Carry on.
Only other point just to reiterate, in response to my Lord Briggs' point, this case isn't against me. What this is precluding is independent action in respect of its independent rights, because it's making clear the member, no longer has them independently. They are subsumed within the collective whole of the group. What it does not say is that a member cannot submit a claim on behalf of the group. Indeed, it surely is necessary for somebody to submit a claim on behalf of the group. And just to reiterate a point I made earlier, one sees at paragraph 20, the court again making quite clear that there's one VAT number that is given, not to one entity, it is given to the group, and that is used by all members of the group. That is the signifier, as it were. That is who one is dealing with for fiscal purposes. Because, of course, a counterparty to a member of the group will just see the VRN number. It won't be told it's part of a VAT group. It's got no interest. It simply sees a VAT number. The VAT number signifies to the Crown that that is a supply, either by or to the group.
Under the statute, my reading of section 43 is that it's envisaging not that that VAT is dealt with by the group at all, but that there's section 43 is a deeming provision which requires the representative member to be treated as carrying on the businesses of all the group members, and therefore to be the person accountable for VAT to the revenue. So it's not so much that the group has some VAT status. It's rather that that where you have a group, the representative member is treated as carrying on the entire business.
Yes.
In a nutshell.
That's the, as it were, rather inchoate model adopted by section 43. And in most situations with an ongoing group, without these long-tailed claims, it works. The issue is when there's a time lag between entitlement and the claim and the group changes. But I do urge upon your lordship what was said by Lord Nolan, which is that may not be in terms what section 43 says, but it has to be interpreted that way. If one does not do so, one reads section 43, and what it does is to deem all the supplies to be made by or to one party, the company X, the representative member. It has all the rights and liabilities, nobody else. It can therefore claim under section 80, nobody else. It is the person who has accounted, and nobody else. The rep member changes the following month. It can't now claim. They've got to go back and say, Company X, can you please come and make the claim that it may have been wound up, it may have been sold on? Because it is the repository on that.
Yeah, I mean, there would surely be operated some sort of understanding of succession. It is a member, it's a VAT entity in its representative capacity. And so if there's a representative changes, all its rights and duties succeed.
Well, I asked rhetorically, with no disrespect, my lord, where does it say that? Because section 43 doesn't have that at all.
Well,
there's no, as it were, assignment by statute or succession. And the reason why there doesn't need to be one is, as I'm going to show you in the European authorities, if one treats the group as being the single taxable person and the repository of their rights on a collective basis administered via, usually, the representative member, that member can change from week to week, and there's no difficulty because the single taxable person remains the same, and therefore, for Section 80 purposes, the person who was accounted 5 years ago, 10 years ago, is the same person, the single taxable person, even though the representative member may have changed 5, 20 times in that period of time.
There are presumably provisions here somewhere which explain how representative member identity can change within a continuing VAT group and what the consequences are.
No. All that is there, my lord, is a provision at the election of the taxpayer that they can give notice to the Crown to change from the following period, and that will be permitted unless the Crown oppose it for grounds of abuse or tax avoidance.
Yeah, but I assume that...
Where's that?
Well, see, that's most easily found in tab 1, 449 is the old section 29, and I take that simply because that's where it's most easily marked up. If one looks at page MS 450, at subparagraph 4, beginning where an application to that effect is made, and subparagraph C. Far from being retrospective, it's only from the beginning of a prescribed accounting period. They're not deemed to have been the representative member previously. And in my submission, there's no need to be, because the single taxable person remains constant. What may change is the person representing them, but the fiction behind it is constant.
So, I mean, you're advocating a solution whereby the law recognises as a continuing entity that group, irrespective of the changes in its constitution. The alternative advocates as a continuing entity the representative member, independent of its identity. Is one solution more surprising than the other? I mean, the law can confer a sort of continuing persona despite the change of identity in either situation, and that's what one situation or the other is doing, isn't it?
Well, in my submission, if your lordship were to say one should treat a representative member as the single taxable person, in my submission, that would not conform with the permissive ability under Article 11, which is to treat persons as if they were a single entity for fiscal purposes.
Well, yeah, I mean, your position, I think, is that the Article 11 tells you what the scheme is, which is the group, the entity. Section 43 or Section 29 is a mechanism for giving that effect, which works perfectly well. But you mustn't take it too far, because otherwise you get into sort of silliness of having new representative members and having new claims.
Exactly.
And one can tell, if one reads Section 43 in the light of the provisions which enable you to change the member,
yes, that
in a way underlines the point that it's mechanism rather than substance.
Yes.
That's sort of...
I'm grateful, my lord, yes.
Who chooses the prescribed accounting period from the beginning of which a substitution of representative member takes effect under Section 29(5)(c)?
Well, that would normally be from, as it were, the next quarter, and it would be in the notice
it may be normally,
from
but
taxpayer.
What it says is a prescribed accounting period, so presumably the taxpayer can choose.
Yes, but not retrospectively, my lord.
Well, is that clear? For the purposes of dealing with overpayments?
The problem is that it can't be in the prior, my lord, because there are 101 invoices sent out to other taxpayers by that, with the rep member. There may have been claims by that member. this only matters vis-a-vis, as it were, vis-a-vis the Crown, from whom it should expect normally to receive the VAT return at the end of the quarter. But it's going to be prospective. I mean, it can give rise to, and I'll come on to this if I need to later, practical issues, as in Jane W. Waste, whereby it could happen that a company is wound up, the representative member is wound up. A time bar is looming on the Friday to submit a claim under Section 80. The constituent members get together to put in a notice to the Crown for the next accounting period, which is on the Monday. But of course, that's not going to be dealt with for weeks. How do they put a claim in if the Crown is right?
Sorry, yes, and what's your solution? They can just, any one of them can do it?
Oh, yes.
You've referred us to Section 29 of the 1983 Act. Presumably there's an equivalent provision in the 1990s.
Yeah, I only say, my lord, because I don't think it's copied in what's behind tab 2, and that's why I went.
Somewhere or other, there must be some equivalent.
If we may, over the short adjournment, try and locate that to the extent it's any different. And there's no difficulty, my lord, in saying that another member can make the claim, because that other member is part of the single taxable person. It doesn't involve issues of agency. It is part of the fiction who has the right. And the reason that is because the grouping terminates the fiscal independence of the members and creates an overarching umbrella fiscal persona under which rest all the members of the group. It's not simply covering the representative. And one gets that from the Commission Against Ireland. This is at tab 35 of the authorities, beginning MS 999. And it's in the discussion, it didn't arise in the court's judgment, which dealt with whether a non-taxable person could be in a group. But in the Advocate General's opinion, beginning at page 1008,
Yes. Which paragraph?
40 and 42, my lord.
Yes.
I could also ask your lordships to read paragraph 43, then I'll just explain why.
Right.
One of the issues was whether, by dint of grouping, one can expand the ability to deduct the recoverability. The point is, no, it doesn't change the fiscal nature of the supplies being made by the members. But I do put some stress on what the Advocate General says when he refers to the right of the persons belonging to the VAT group. This is not the idea that one condenses individuals into just the representative member. What is being posited is that there is a fictional group comprised of members, and those members have rights to deduct. They may be administered via some mechanism vis-à-vis the state, but they have rights together, because collectively they are a whole. For fiscal purposes, they are a unified whole.
It seems to me that if this is a critical area of this case, some issues might arise which would require a reference.
If I may, my Lord, I'll reflect on that and take instructions. There is always a danger with references of that, which may come back. The European Court have been quite clear about the nature of the rights inter se.
No, but what one would be asking, whether in the light of the freedom which member states have to implement directives in slightly different ways, and no doubt in the light of a good deal of further information about how different countries have implemented VAT in their different ways, the UK system can operate according to its terms, or whether it requires to be reinterpreted or possibly struck down as incompatible.
Well, that only arises if your Lordship rejected this contention and were to conclude that the operation of Section 43 was in fact to give rights exclusively to the representative member.
Yes, I mean, obviously it would only arise if we didn't accept your submissions to the full.
And I'm not sure, I'm sure my own friends will also take instructions. I'm not sure that that very extreme view, that one to which the Crown necessarily subscribe either. So it's not necessarily a view being urged upon your Lordship by either party, although I will of course let Mr Young speak for his own client. It would involve a substantial shift in the accepted view post-Thorn, which is it may not be exactly what Section 43 says, but we know from IDT just how vigorous and strong-armed a purposive construction can be. Therefore, looking at Section 43, what's it meant to do? Create a single taxable person. We know that from Europe. That's what it does. That's what Lord Nolan said. That's how it's been operated in practice.
Is there some commentary on this? I mean, we've made some very clear submissions, but there must be authorities on VAT which have discussed this fundamental question.
There are many doctoral theses from the Netherlands which one might have read.
From the Netherlands?
So they are very erudite, but say nothing on this particular topic, my lord. And they're not cheap either. But they don't address the issue of who has the right in the context of a departure. There are very different models, and Germany has a slightly different model as to who's the holder of the rights. There could, for example, be...
Well, wait a minute. I mean, that itself is rather interesting. Doesn't it rather confirm what I was suggesting, that there may be different ways of implementing the directive?
Well, there will be, my lord, in every member state. For example, there could well have been here a requirement for there to be a corporation. It may be in Ireland that they adopt a partnership model. My point is that those differences of implementation may deal with the practicalities of how to deal with the rights inter se between the members. That's my private law sphere argument. They're not going to inform the antecedent issue under the directive, which is those members are treated as a unified whole, because that has to be uniform. That's what Article 11 says. They treat the persons as a single taxable person. Now, one may then have issues under domestic law as to whether the rights being afforded the individuals under domestic law conform with that model in Europe. The problem with your lordships is Section 43 does not deal with that issue, because the VAT Act, as the VAT Code on that public law fiscal plane, is not concerned with the individual rights. It's dealing with the collective rights, with the single taxable person. And the issue is, for your lordship, is that just the representative member, or does it include the body who have put in the group registration? And in my submission, it's the latter, not the former.
Mr. Scory, can I just test a little further your apparently quite forceful point that if the representative member goes bust and gets wound up, then reclaims of overpayments for some earlier accounting period fall into some kind of black hole unless you're right. Is the way in which one claims a previous overpayment back to reopen an earlier accounting period, or does one make it as part of one's VAT return for the current accounting period? I ask because I have a dim recollection of being some sort of representative VAT member of my old chambers. And I vaguely recall that the return form does have 2 lines about overpayments or underpayments in previous accounting periods, but it's all dealt with as part of the current accounting period.
Anything below £2,500 can be dealt with in the current return. If it's, there's a figure, but it's rather low, and I'm sure those behind Mrs. Young will correct me if I got that figure wrong. But if it's a small amount, it can be dealt, and I should have claimed it in the last quarter, I can put it on this quarter. Anything substantial needs to be a separate Section 80 claim, and there are then regulations as to how that is to be done, and that's Regulation 30, at tab 6, page 469, which is very brief, made in writing with any necessary documents. So, in answer to your Lordship's question, there needs to be a specific claim referable to that prior period.
It's not dealt with as part of the return for the current period.
And just to reinforce both that point, my Lord, and my Lord Mance's point that it's not peculiar to the representative member, if a claim goes in by the VAT group in respect, and it's submitted by the representative member in respect of a period in 2015, so we're in time, and it says that supplies actually should have been exempt, and therefore it seeks a reclaim of the overpaid output tax. There's not simply going to be a repayment back by the revenue of the overpaid output tax. The revenue will deduct the input tax, which was wrongly reclaimed, because it should have been partially exempt. So therefore they will balance out on the single VAT account. And that will be the case whether the representative member is the same or differs. It's referable back to the period in question. It doesn't matter who is at the interface with the revenue, whether that person has changed. So I'd just taken your lordships to the Advocate General in Ireland. Can I just check? Scandia is the other major European case at tab 37. At beginning, my Lord, forgive me, 1047.
Thank you.
I'm sorry to interrupt you, I'm just thinking aloud. It might be worth sharing it with you. Just thinking aloud, if you have a group, for example, in the present case, it rather looks as though this group had bingo halls, it also had cinemas. And just say you had the representative member was the cinema operator, for the sake of argument. And it was accounting for the VAT on the bingo halls. And then it turns out, donkey's years later, that in fact there was no VAT due on the bingo services at all. In terms of Section 80, the person who accounted for the VAT was a cinema operator, and on the face, if one looked no further, on the face of Section 80, one would think that that would be the person under Section 80 who would be entitled to make the claim. And just say that that company was no longer part of the group. At the end of the day, Section 80 is meant to enable San Giorgio claims to be met. And I suppose one would then have to ask, well, in terms of the San Giorgio line of authority, who would have the San Giorgio claim? I'm inclined to think the answer would be that it was the bingo hall operating company that had the San Giorgio claim.
The real world supplier?
Yeah. But in which event there might be a basis for a claim outside Section 80. But I mean, that's a question of EU law. Who has the San Giorgio claim in a situation where there's been a change in the membership of a group of the kind that I've posited? And,
it doesn't arise, and I'm not trying to dodge this, you might. It doesn't arise on this case. Unlike the issue of ratification, which in our submission we have probably argued, at that point certainly neither side has.
Simply because it's not been argued.
It's not been argued.
Right.
And it's not a matter of when there's been a change in that sense. In my submission, it's common ground between the parties that for the purposes of this appeal, the right belongs to the group. The issue we're then dealing with is...
Who were surviving members of the group?
Well, it's common ground from the Crown that the party entitled to this amount of money on the bingo halls was my client, the representative member, even though at least post-1990 the real-world supplier may have departed.
Because you embody the group,
Yes.
although apparently you don't embody the right to make claims on behalf of the group.
Apparently not. So says the Crown, no.
Yeah. Yeah.
Yes.
So if you had been wound up and dissolved, the only way to make the claim would be by getting the company reconstituted, and the claim either then being pursued by the liquidator or he assigning it to somebody else and that person doing it as an assignee.
Yes. Or, in my submission...
Or anybody can do it.
Well, not anybody, my lord.
Anybody within the group.
Any member.
Yeah.
Because they're part of the single taxable person. Now, again, this doesn't lead to multiplicity of claims in the normal situation, because the very notion of a VAT group presumes control and coordination, so that's not going to happen. It's only in extreme cases. Even the Crown accepts that in that situation of liquidation, then what they say should be the normal rule won't apply, and one has to devise a different way, and below it's thought, well, do the principles of effectiveness mean one has to give a right where there otherwise wouldn't be one? My argument, one needn't do that. One needn't tinker with the basic structure. The rights are with the group. They are normally administered via the representative. If that breaks down, the group's still there, fiscally. If one can say that a fiction persists, the fiction is still there, the umbrella over the members, and therefore one of them, or all together, can make the claim. And that would be a valid assertion of the group's right. And in many respects, we had thought that this was common ground. If I may, the one authority which has dealt with this in the most detail, albeit still on appeal, so it comes with a health warning, as it were, is the MC Rover appeals, where there are a number of appellants. And that is at tab 28 of authorities, page MS 883.
Which bit are we looking at?
Forgive me, page 909. Paragraph 118. And if one also looks down at paragraph 120 between D and E, and that discussion reflects the view of that tribunal that the collective members of the group have rights as the single taxable person. They are entangled, as said in paragraph 120, but they are, as it were, the rights of the group. They may normally be administered by the representative, but they're the groups. And one sees that on page 911 at paragraph 126, third line.
Sorry, I missed that one.
911, page 911, MS 911, paragraph 126, my lord, top of the page.
Yes, I'm with you. Yeah.
And if one flicks on to page 919 at paragraph 172, and if one then looks up at the preceding paragraph 169, the judge makes a rather obvious point. Principal contact for the revenue is the representative. We don't dispute that, but we say it's not the exclusive one.
Well, it doesn't the end of 172 slightly create a problem for your submissions?
Well, I'm going to come on to that now. I'm going to go back, my lord, but actually go back to page 127.
Paragraph 127.
Paragraph 127. In my submission, what happens here is a slight elision in the analysis due to the facts of that case. But you will recall, my lord, at paragraph 126, there is the view consistent with my submission, the rights vest with the representative member. One then has a 127, the statement that they vest with the representative member. There's a rejection in 128 that the representative member is not to be equated with a single taxable person. And then there is the point at paragraph 173 and the end of 172, to which your lordship just alluded, where Mr. Justice Warren appears to go a step further and say only the representative can. In my submission, there's an elision there between the rights of the single taxable person and the representative member. And it arose in that case because there was no dispute about who claimed. The dispute in that case was between erstwhile members who had put in claims in time and the representative member who had put in claims in time. And they were, who's entitled? The real world supplier who says, I wish to disentangle my rights and be treated independently, or is it the collective whole which is ongoing?
So the elision is of the rights of the VAT group and the rights of the representative member.
Yes,
claim.
yes. In contrast to the competing rights of the individual real world supplier, because those are the two competing interests. And then in my submission, the learning judge can be forgiven for conflating the group with the representative member.
So which is the sentence you say is not strictly accurate?
One looks at paragraph 172, the beginning, consistent with my analysis, the group has it, but one drops down to letter F. He seems to suggest that only the representative can.
Yes, I see. So that's a sentence.
And the real nub of it, one sees at paragraph 175, he's talking about who's entitled to receive the payment, because this was in a plead action. The crowd, like here, the crowd admitted that it was due. There were various competing claimants, namely the group or the real world supplier, and he's really talking about the ability, the right to receive it. It wasn't the same context as here, which is who's got the right to make the formal claim for the purposes of Section 80. That wasn't in dispute.
If you look at paragraphs 167 to 168 on MS 918, don't they put the matter the opposite way round to the way you'd like us to see it? I mean, you'd like us to say national law is just a mechanism, what the fundamental is European law. The court, the upper tribunal here, appears to be saying European law is just a framework, national law has a good deal of discretion, and the English scheme may easily be read as giving effect to the requirements of EU law and operating within the discretion, the margin of discretion afforded to the member state. That's what this is saying, isn't it?
Yes, it was, because in that case, the real world supplier who had departed was asserting all sorts of quasi-private law rights, and also rights as a party bearing the economic burden to be entitled to the VAT, irrespective of whether there was a group there or not. And the issue there was, how does the Section 43 mechanism deal with those rights once the mechanism collapses and nobody's in the group anymore? That's not this case. Taylor Clark and the Crown, are operating under the existing grouping regime. It's common ground that although we are formally disbanded, its effect is continuing for the purposes of this claim. So those points don't arise in the same stark way in this appeal.
Yes.
And if this this analysis, your Lordship shall appreciate, in my submission is consistent with what the European authorities say. And if 120 is correct, namely that not only are the rights enjoyed by the group members as a whole, collectively, but if one leaves at best with only an interest in those entangled collective rights, and the precise allocation is a matter of private law, said Mr. Justice Warren. He wasn't going to work that out for the parties. It means that when transposed to this case, when the claim is made by Carlton, not asserting its own losses, not asserting its own supplies, but asserting the rights that properly belong to the single taxable person, then that is a valid claim in time, and no issue of agency actually arises. Now, I've not actually taken your Lordships to the claims themselves, which, in my submission, is the next appropriate step in light of those principles. I'm conscious of the time.
Well, you've got a few more minutes.
So if we would start there, my Lord, at page 376. Now, my learned friend criticised the extra division's lack of textual analysis. Well, if I can, if that's right, if I can remedy that, if one looks at this document, it is on Carlton's paper. That is without doubt. But in and of itself, that tells one, in my submission, nothing, particularly when one bears in mind that when one is a member of a VAT group, and when Carlton was a member, this paper would have been the same in all its contracts with third parties and any communications with the revenue. And it would have had on it the same VRN, because that's the group's VRN. I cannot stress too much the importance of that VRN. Hopefully on this document there's also a reference to Taylor Clark Leisure Limited, the representative member. But that number is the group's number. It is the number under which the claim is being made. Now you may recall from paragraph 49 of the Crown's written case, MS page 65, it said this point is neutral, because there must always be a link to a VRN. With respect, that ignores its importance. That number is the signifier for the group. It is a reference to the rolling VAT account between the parties. That means that when a claim is made for a given period by a taxpayer, in this case the single taxable person, the Crown can then see whether there needs to be any set-off under Section 81. It also, for practical purposes, has attached to it a bank account, which is the authorised bank account which monies are paid. And that, no doubt, is the reason why, in respect to the fourth of the claims, the money was paid to my client, because that wasn't manually overridden. And you will note from the first paragraph, this is prior to Fleming, so it's a protective claim. So it's putting in claims back in time further than the usual 3 years, in the hope that that's what the House of Lords will decide. That's relevant because there were prior claims, and that's clear from paragraph 3. But those can only have been on the basis of the then existing 3-year cap, and therefore they would have been personal to Carlton, because at that point in time it was an independent taxpayer, although one presumes that in making a claim, any such claim letter by Carlton then would have had its own VAT number and not my client's.
Would that be a convenient moment?
Lord, yes.
How are you doing in terms of time? Obviously you will have got an arrangement with Mr. Simpson, but...
I hope to be no more than half an hour, my lord.
Yes. And how long are you likely to be, Mr. Simpson?
Well, I wouldn't expect to be more than half an hour.
Well, you're
a lot to cover, but,
somewhat overrunning your time, but I think the case has points which merit it. Right, 2 o'clock.